委員，我哋而家
Members, we've already formed a quorum, so I now call the meeting to order. After the last meeting, we've issued the following papers. CB bracket 4567/1314 bracket 01, submission from 2 members of the public expressing their dissatisfaction about the appointment of a registrar of the Court of Final Appeal, which is in English only and is restricted to members for reference only. The next paper is paper CB bracket 4579/1314 bracket 01, a submission from parents for the Family Association on the adjudication of cases by the courts. This is in Chinese only. As for the items for discussion at the next meeting, we've got 2 papers, CB bracket 4569 bracket 01, list of outstanding items for discussion, and CB bracket 4569 bracket 02, the list of follow-up actions. For the next meeting, that is to be held on the 27th of May, a Tuesday at 4:30 p.m., we've proposed 2 items for discussion. First, implementation of the recommendations made by the Law Reform Commission. This has been agreed to by the government. The Law Reform Commission, LRC, has provided its first report to the panel on the latest progress. And the other item proposed by the chairman and deputy chairman is draft solicitor cooperation rules and consequential amendments to Legal Practitioners Ordinance, Cap 159. This has also been agreed to by the government. This is item 2 on the list of outstanding items. Earlier, the Law Society wrote in on solicitor corporations, that is whether or not they should take out top-up professional indemnity insurance and notify clients of the identity of the supervising partners. They would like to consult the panel. Now, these are related to broad public interests, so we suggest that this be discussed at the next meeting. So I'd like to see whether members agree that these 2 items be put on the May agenda. Mr. Alberto? Well, the first item is rather vague. It's about the first report to the panel. Would this be very simple? Then we can use more time for another item. Mr. Ho, we did ask the administration the same question. They discussed among themselves and envisaged that members would like to follow up on a couple of issues more when they present their report. Protection of witnesses, of sexual offenses, and other issues of concern, as indicated in the past. Before the next meeting, I ask them for the latest situation on their report. We'll urge the administration, including the DOJ, to come and explain their work to us. In June and July, we've already got some proposed items for discussion. I've tried to make some arrangements with them, and they said that June and July would be appropriate. So they proposed to discuss the LRC report and the follow-up matters at the next meeting. If we still have time, I can add a couple more issues that are of interest to members. So thank you, Mr. Ho, for your comments. So if you do not have further comments, we'll have these 2 items on the next agenda. So we now proceed to the agenda items today. First, review on family procedure rules, paper 569 bracket 03. Is the administration's paper on review of family procedure rules, interim report and consultative paper. We have invited other LegCo members to attend this meeting. So now I'll invite the representatives of the Judiciary Administration to come in. On the 17th of February this year, the Review of Family Procedure Rules interim report and consultation paper was published to improve the family law administration and a whole series of recommendations. When members met with the Judiciary Administration last December, it's also said that a presentation will be done. So I'll now invite the representative of the Judiciary Administrator to do a PowerPoint presentation, and then I'll invite the Law Society and the Bar Society and the Hong Kong Bar Association to speak. Thank you, Madam Chairman. We're very pleased to have this opportunity to introduce to you the interim report and consultation paper of the Review of Family Procedure Rules, which was published by the Working Party to the paper. And today we're also grateful to the Department of Justice, the Family Law Association, the Bar Association, and the Law Society for attending to assist us today. My other colleagues will also take part in this presentation. As the chairman said, the Working Party was appointed by the Chief Justice in March 2012. And Mr. Poon Siu Cho of the Court of First Instance chaired the Working Party, which comprises judges from the Family Court and the High Court. We also have representatives from the Legal Aid Department, the Bar Association, the Law Society, the judges of the High Court and Family Court, Family Law Association, and Department of Justice and Legal Aid Department to assist us. The Working Party is to advise the Chief Justice on the desirability, impact, and practicalities of formulating a single set of procedural rules for the family jurisdiction applicable both to the Family Court and the High Court. I'll defer to Ms. Cheung for further details. Yes, thank you, Madam Chairman. I'll now introduce the background of this issue to us. Our family justice system covers a number of matters, including matrimonial issues, financial issues, children proceedings, and other issues. Why do we need this review? First of all, we saw that in many family litigations, there were adversarial excesses and fragmented and labyrinthine court procedures. And not all procedures in the High Court have been adopted in family courts.
Secondly, there are a lot of fragmentation and labyrinthine court procedures, so it causes some confusion. And reason C is that many family proceedings have no dedicated rules of their own, so very often, as indeed, they need to cross-reference to the rules of the High Court or the District Court, and in some cases, the practice in England. Now, the fifth reason is that because there were different rules in different legislation, so therefore the rule-making authorities are different. Now, it might be the Chief Justices at different levels, and so on. and even the CE. And we looked at the international experience, that is England, Australia, and New Zealand. Now, these are common law jurisdictions. They already have unified procedural code for family and matrimonial proceedings. So therefore, our review is to achieve the following effects. Firstly, we hope to shift towards a more conciliatory approach. There should be a self-contained procedural code. And thirdly, the procedures should be more efficient, effective, and user-friendly. And then we will inform you on some of the more major proposals out of the 130-odd proposals we have. First, the general approach. Now, in England, they have a family procedure rules of 2010. This is broad and basic framework, and we will use this as our reference basis, the FPR 2010. And then in Hong Kong, we already have the Hong Kong rules of the High Court. This is more attuned to our local system. And in B, we select appropriate provisions from the FPR 2010 of England. And we emphasize the review is confined to court procedures. We will not deal with substantive law. For instance, maybe the substantive law is dealing with the division of property between the spouses, but here we just deal with what forms they have to fill out, what court procedures they have to go through. Now, a major proposal is that there will be a unified procedural code called the new code, and that applies to all family-related procedures, and it applies to both High Court and Family Court, and all matrimonial and family proceedings will be unified as a result. And another important proposal is that under usual civil proceedings since 2009, we have instituted a civil justice reform, and there are various beneficial aspects that we will apply to the family procedures, such as alternative resolution and so on. And we also take into account the approaches in the High Court and District Court. So we have registrar and masters to assist in simple judicial court, and as in those courts, we hope to have a new single rule-making authority. Next, I will invite the DOJ to inform us about the more detailed proposals. Thank you. We'll go into the more detailed proposals. There are four aspects. First, the general issues. Second, matrimonial issues. Thirdly, financial issues. And D, children issues. Now, on general issues, the proposal is that there will be set out the jurisdictions of the Family Court and High Court, and the Family Court, children and monetary jurisdiction, High Court, exclusive jurisdiction and inherent jurisdiction in children matters. Now, the new code will adopt the civil justice reform objectives with regard to welfare issues, and the new code proposes that there will be alternative dispute resolution procedures to enhance courts' powers in promoting alternative dispute resolution and enhance family mediation. Now, and Practice Code 15.10 on family proceedings. We want to find out whether there need to be further improvements. And then there is also enhancement to enhancement of pre-trial proceedings to explore resolution possibilities. The working group proposes that the new code should specify that in general the court proceedings should begin in family court, and there should be simple, focused, and efficient practice and procedure for transfer and or retransfer, and there should be unified code of originating process and new statutory forms. All this also the new code will align the terminologies, for instance, applicant and instead of respondent, and also instead of ancillary relief, financial order. And the working code views that there should be a single self-contained set of rules on enforcement to be included in the new code. It will apply to family and matrimonial proceedings. So instead of referring to different rules, certain high court rules, so all these, instead of having these separate rules, we have a new single self-contained set of rules. And rules applicable to the domestic violence and cohabitation relationship violence ordinance to be incorporated without changes. Now, on matrimonial issues, the working group proposes that the essential features in the matrimonial causes rules to be retained and incorporated. Special procedure for undefended case to become the norm. The new code should clarify and consolidate procedure for applications of rescission of matrimonial decree and making a decree absolute. Now, concerning attempts at reconciliation, they should apply to both represented and unrepresented cases. Right now, it only applies to represented cases, whereas right now there would be a different representation procedure for the other case. Now, the court is to determine whether medical examiners should be appointed in nullity proceedings without the need for application. Now, on financial issues, the working group proposes that there would be a compendious code for financial applications in all family proceedings in the family court and high court. There will be standardized originating applications, summonses, forms, and affidavits. We will maintain the present default code of hearing in chambers, that is, hearings not open to the public. For resolution of financial dispute, the rules are being made in a separate legislative exercise. Also, it's proposed to replace former complicated and technical practice, for instance, standardized forms instead of affidavits. Now, because there are differences from general civil proceedings, sanctioned offers are not to apply. Now, this new part for proceedings under inheritance, provision for family and dependent ordinance. So persons affected, for instance, beneficiaries of estate, joint tenant of property, are to be named and served. And directions are to be given for mediation or for the financial dispute resolution procedure. Now, on children issues, the working group proposes that there will be unified procedural rules for all extant children proceedings under various ordinances. There will be a general single unified term for child subject to any contrary definition in existing ordinances. Now, for dispute resolution regarding children, this will be incorporated into the new code. We want to seek people's views on whether this can be extended to the High Court. The new code proposes that existing procedures under matrimonial causes rules on custody, care and provision, removal and related matters to be generally and mostly incorporated. The working group also proposes that there will be made new provisions for practice and procedure for applications related to parentage, etc., under the Parent and Child Ordinance. For instance, the status of parents. Now, directions for scientific tests to be stipulated by rules, practice, or guidance notes. So this is also an area where we will seek people's views, and also to incorporate judiciary's existing guidance on separate representation for children in matrimonial and family proceedings in the new code. So views are also being sought on this. Also, our next stage of work.
We're now in a consultation period which started from the 17th of February and will last till the 16th of June. The consultees include electoral members of the legal profession, relevant committees, the welfare sector, and other stakeholders. You might have noticed from the foregoing proposals that we need to have legislative amendments to principal and subsidiary legislations. After collecting all views in June, our next steps will be tentatively as follows. We'll prepare a final report, that is, the working party, after reading the stakeholders' views, will collate and tidy their original proposals and submit a report to the Chief Justice of the Court of Final Appeal to see whether the recommendations will be adopted. The final report should be completed by the first quarter of next year. Then we'll formally proceed to legislative amendments, which will start in the second quarter of next year. So much for our briefing today. Thank you, representatives from the judiciary and the DOJ. I'll now invite the representatives of the Law Society and the Bar Association to speak. Would it be from the Law Society first? Mr. Hong, Mr. Anthony James Hong, Vice Chairman of Family Law Committee.
Family Law Committee of the Law Society coming here today. The Family Law Committee acknowledges that there's a lot of problems in the consultation papers and welcome the reviews of the family procedures law. We actually had 2 meetings already and a very long meeting, and we will hope that by the 16th of June 2014 we will give a very substantive our answers and our recommendations to the committee. In principle, the Family Law Committee agrees to the introduction of this new code, a standalone unified procedure which should address these issues identified in the consultative paper and comprehensively deal with the process and procedure in family and matrimonial jurisdictions. It's time that we should do it. Also, that we agree that the setting up of a new Family Procedural Rules Committee, this is very, very important in order that not need to be, is more simplified. That is our views. And also, we also agree that the English, the Family Procedural Rules 2010 from the United Kingdom, we agree that that should be used as a base framework for the new code. Of course, with amendments towards Hong Kong catering for the Hong Kong situations. The Family Law Committee also agrees in principle that it is necessary to introduce consequential amendments to the relevant principal ordinance and or subsidiary legislation to improve these procedures. We wholeheartedly support these amendments. Thank you.
多謝洪生。其他嘅代表有冇補充？冇咧，我哋就。
What about other deputations? Any more questions? Otherwise, I'll invite Mr. Robin Egerton from the Bar Association to speak.
The Bar Association welcomes the opportunity to be involved in this consultation, and in particular recognises the importance of streamlining procedures in all areas of family law and the objective of bringing about consistency between the matrimonial causes rules and the rules of the High Court of Justice. And we look forward to participating and finalising our response by the 16th of June 2014. However, it is important to note that there is no point these recommendations going forward unless there is action, because of course the experience of family law is extremely disappointing in this area, where the law reform recommendations in 2005 in relation to custody, care and control have not been acted upon. So we want to see action, not simply window dressing. Thank you, Madam Chair.
多謝艾生。嗱，咁咧而家咧就係到。
Thank you. Now it's time for our members to ask questions. For the first round, I suggest 4 minutes per member. For the moment, I have 3 members on the list. I'll try as far as possible to let you ask all your questions. I'll be more lenient. And if I see more hands later, I'll be stricter on this. First, Mr. Tan Ka-Piu. Thank you, Madam Chairman. Well, we understand that most amendments are related to language and procedures. However, I understand that there will also be substantial changes to the procedures also. And most importantly, we have conciliation and pre-conciliation proposals. I'm a member of the welfare panel and a frontline social worker. I fully understand that ultimately social workers will be receiving most questions, and social workers focusing on family matters. For the 40 SWD centers, the social workers will also have to write a lot of reports on whether or not a divorce should be taken out, how to take out a divorce, what sort of agony will be experienced in that process, and what about matrimony or alimony if I'm a father, but the custody of the child goes to the other party. I will have to approach social workers. So eventually all the additional workload will go to the social workers. I understand that the welfare sector had been consulted, but how did you listen to the views of the welfare sector? How are you going to listen to them in future, such that most members of the public and the frontliners of the various professions would have their views heard, such that the relevant laws will be amended in the best manner? And will you provide a platform for the welfare sector to air their views? Who will answer the questions? Ms. Cheung? Well, we agree that the welfare sector is a major shareholder or stakeholder. On the 22nd of March, we conducted a consultation session, and immediately after the publication of the report, we contacted the Hong Kong Council of Social Service. On the 22nd of March, we had this large-scale consultation session. Many attendees were lawyers, but many other participants were from the welfare sector, the social workers. The family welfare centers under the SWD will be affected. So the Labour and Welfare Bureau and the Social Welfare Department were also invited to attend. And we understand that some consultative committees will also be relevant stakeholders. So we also went to the Women's Commission for a briefing. In early June, we'll also go to the Family Council to do a presentation. After listening to our briefings, if they want more detailed reports or presentations, we welcome such proposals. The HKCSS is already studying our report, will also accede to the request of the LWB and the SWD. When we passed this paper to the LegCo, we also told your Secretariat that we welcome views from other panels as well, for example, the Home Affairs panel. But of course, we would discuss with the Welfare panel as well. Well, I'll of course talk to the Welfare Services panel. As I announced just now, for this meeting, we've invited other LegCo members to participate, envisaging that this may be a cross-bureau matter. Mr. Dennis Kwok, Madam Chairman, I noted that this is basically a procedural review. Generally speaking, the legal profession agrees that the procedure rules should be reviewed. But as the representative of the Bar Association said just now, in 2005, the Law Reform Commission already published a report on the custody of children. But many recommendations had not been implemented. Not just the Bar asked you to do this. I noted that in a recent case of the Court of Appeal, Mr. Joseph Lam Hon.
Recommendations of our Law Reform Commission in 2005 regarding child custody and access have not been taken forward. Had such recommendations been implemented, the respective rights and responsibilities of the parents towards their children would be more clearly and specifically defined. Judging from the submissions advanced by the parties in this case, I cannot help from observing that with the implementation of such reforms, appeals like the present one could have been avoided. Speaking for myself, I would like to take this opportunity to urge the administration to make some progress in these directions. Now, 即係我哋知道咧，法律改革委員會其實有好多報告。
So the Law Reform Commission had actually published a report without being followed up on. Now, this is a very good example. In 2005, a 300-odd-page report was published, but then not all recommendations were implemented. So this time, we should follow up on those recommendations of the LRC as well. I can see that the Working Party's members are also attending today. Will they be able to air their views? Well, if they're willing to give us their views, we would welcome that. Mr. Ng said, members can also ask them questions. Ms. Cheung, would you like to respond first? Well, for the few representatives sitting at the back, Mr. Kwok asked whether you have any responses. Well, a simple response to Mr. Kwok's comments. We noted the 2005 LRC report, but that was related to substantive laws. I understand that the Labour and Welfare Bureau is following up on that report. One or two recommendations in that report had been included in this exercise. For example, whether the child should be represented by another lawyer. The judiciary administrator already published guidelines to the effect that in this consultation exercise, will study whether or not a new piece of legislation should be enacted. We're consulting the LWB because we understand that there will be policy implications. And there will be questions like whether or not the child should be entitled to legal aid. So it's not just related to the judiciary or the courts, but also the administration, the executive. Well, what about the specific legislative amendments? Has the DOJ actively consulted the relevant parties to see whether or when we'll see substantial or substantive legislative amendments? Ms. Ho? Madam Chairman, I understand that the LWB is actively working on this. I recall that recently they submitted a paper to the Welfare Services Panel saying that by the end of next year or early next year, they would be ready to present a draft piece of legislation for consultation with relevant stakeholders. What about those sitting at the back? Mr. Ho, concerning Mr. Dennis Kwok's comments, I understand that this exercise is about procedural matters. As regards issues related to children, the dispute resolution procedures involving children started in about October 2010, if I remember correctly. In that regard, procedure-wise, the objective of this exercise is to allow the two parents to resolve child matters. Appropriately. To a certain extent, this is a follow-up on the LRC's report of 2005. So if legislative amendments can be completed, we'll be able to see substantive legal changes. But even before we see such changes, improvement on procedures is also very good. And understand that the proposed procedures will be extended to the High Court, because in this exercise we are confining ourselves to family court. Well, the speaker just now was Mr. Dennis Ho, representative of the Law Society of Hong Kong. Next, Mr. Albert Ho. Madam Chairman, I'd like to follow up on the comments of Mr. Dennis Kwok and Mr. Robin Edgerton, representative of the Bar Association, concerning the custodian rights of children. If there's no decision to carry out a substantive law reform, then even if procedures are improved, it's not that meaningful, because you'll still be subject to the constraints of the principal ordinance. You cannot assume that proposed amendments to the principal ordinance would be enacted. So in future, we may find our efforts wasted. We may be putting the cart before the horse. Now, this is very important.
程序你真係好多嘢咧，可能係之前嘅一啲所謂 pre-action。
Now, there is a lot of pre-action protocol that has to be changed. And you have to look at the authority. And when the new legislation is passed, you may need more new social workers and community centers for meetings with parents on joint custody and so on. So if you don't know whether the principal legislation is changed and you go ahead with consultation, you don't know what the resources implications would be, then how can you go ahead? I think that would be a somewhat wasteful use of time, and the government has taken so long. And the question was asked on the very often the children's will matters in family court proceedings, in wardship cases. So how much voice does the child have? So the legally appointed lawyer, what is his role? So you cannot separate the substantive principal legislation and the proceedings. Yes, we can't just amend the proceedings without amending the legislation. Ms. Chung, let me respond briefly. We are now at a preliminary stage. We are in the consultation stage. What we're doing is that most of the proceedings mentioned will not be subject to major change, but they are now in different legislation, and we want to put them together so to a certain extent there's relationship to the principal legislation, of course. So we can't sit by and do nothing until the principal legislation is done. So we will try to put as much of the principal legislation as possible into the new code, and when the principal legislation is changed, we will make changes correspondingly. The process may take several years, and if the Labor and Welfare Bureau has done certain things by then, we will make corresponding changes. So we will continue to liaise with Labor and Welfare Bureau on their progress. I think this is unsound, but I know that Labor and Welfare Bureau does drag its feet. They say that different groups have different views now, but still you must have a decision at some time. It's very regrettable. Now on the maintenance and inheritance of property, now this is not part of the proceedings for relating to inheritance in probate court, but in family court. Now, actually, previously, CAP 481 applications very often are dealt with in district court or high court, but Justice Slam of Court of Appeal in a case 2 or 3 years ago said that CAP 411 applications will all come under family court. So because of that precedent, therefore, that kind of applications are now under family court. So in this consultation document is included. Now, on Mr. Ho's question, I'd like to supplement. Now, the Chief Justice of the CFA's direction to the working group is limited to procedural changes. There are no directions for us to make changes to substantive law. And also, the LLC proposals of 2005, of course, they are important, and the Bar Association refer to that, but it will not affect the majority of the consultation this time. For instance, financial applications procedures, most of that. So the 2005 proposals will not be affected substantially. Mr. Chen is of the Bar Association. Next, Mr. Chung Kok Bun. My question is also about the need to amend the principal and subsidiary legislation. We know that the principal and subsidiary legislation, now following the amendment, now, well, actually, it said that only the procedures will be amended. Now, but after you amend the principal and subsidiary legislation, you can't just make changes to the procedures. So there will be final changes to the legislation. Now, we may need to have a new principal legislation on family proceedings. For instance, there may be a new rules committee, what authority it will have, and what rules will be set, and what will be the objectives of those rules, what will be the scope, and there will be corresponding amendments. For instance, in 9 principal legislations, there are references to the powers related to these. So we may have to delete those powers in those 9 pieces of legislation and make so these will be the changes to the principal legislation, but they are not on substantive law but on procedural matters. And what we will put in the new legislation is that there will be, for instance, a new registrar or masters, and the scope of work will be the part of the scope of that new legislation. That's what we are thinking of. Next, Mr. Paul Chair. Now, I beg to differ from Mr. Albert Ho's views because we are talking about this reform as a platform. So it will. I hope we can proceed with this platform as quickly as possible. There are many different areas in family proceedings. Now, many parents are not really that concerned about custody these days. They are more concerned about the financial aspects. And the paper mentioned that in the CJR of 2009, there hasn't been very significant impact on family proceedings. So on dispute resolution, etc., I think that has more to do with family law. So I'd like to ask the experts here to share with us why is it that the CJR's progress on family law hasn't been that pronounced. Let me try to respond. Now, the CJR reforms are mainly concerned with general civil actions. Now, most of the reforms have not affected family court proceedings. Now, as for helping people resolve disputes or come to reconciliation, now, it doesn't really quite apply to family court proceedings. Now, one of the working group's proposals is to stipulate clearly that it doesn't apply to family court proceedings. So, family court proceedings are not really affected that much. So the reforms are urgent because the CJR, even though there has been a lot of effort on it, there hasn't been much that we can use regarding family court proceedings. Next, second round of questions. Mr. Kwok Wing Hang. I think the views of everyone is clear. Now, apart from reforming the procedural rules, we hope that the administration will quickly review and see whether the 2005 LRC report, the substantive legislation can be amended, because even if we amend the proceedings, the substantive law regarding family law still lags behind. Now, looking at the civil justice reform experience, very often you amend the rules, they have progressed, and yet when you come to the court in terms of time and speed and effectiveness, there hasn't been that much improvement, because the waiting time is still very long, despite CJR, because there is a shortage of manpower. I know the representatives are not here. Now, even though you amend the rules, there are not enough judges and officers at the family court. So you are unable to reduce the cost and shorten the time. So I hope the judiciary and the administration will increase the resources at the family court. Well, if you go to the district court in Wan Chai, it's very dilapidated. Moreover, there's a shortage of judges. So there should be more resources as quickly as possible. I have a proposal regarding the LRC report of 2005. Now, my wording has been, the wording of my motion has been passed to other members. We hope that the administration will look at the 2005 report as quickly as possible, so as to implement the proposals therein in terms of the principal legislation. The judiciary and the DOJ, any response? Now, concerning the resources issue, now in our consultation document, we also mentioned manpower and future resources, and the proposal is that whether there should be an increase in the number of masters and the registrar. So in the consultation procedure, we will examine this in detail, and if we do need resources later, we will consider that. So we do attach importance to that.
Any response? I'd also like to ask some follow-up questions, in particular in relation to family disputes. We've been encouraging conciliation for a number of years. Can you tell us your experience in this regard? As for this procedural review, time and resources were mentioned by members just now, and there's also this issue of streamlining. In Hong Kong, in particular, for the unrepresented party, very often he or she lost out very severely in relation to distribution of assets. Now, after amendments are made to procedures, as Ms. Ho told us, they would come very soon for legislative amendments. What about distribution of assets, custodian rights, etc.? Would you encourage conciliation because the unrepresented party does not understand his or her rights? He or she may have to approach district councillors, and in certain cases it's really tragic. The child does not go to either the father or the father, but to a third party. So, can you tell us more details on the mainland, I understand that before they handle a divorce case, they would propose a so-called cooling period for both parties. In the interim, they would encourage social workers or counselors to assist the parties concerned, such that they don't need actually to go to litigation or even take out a divorce, because very often family tragedies are involved. Can I have some responses? Mr. Jeremy Chan? Well, I can respond to your remarks partially. We have FDR and CDR procedures. FDR is related to financial matters and CDR is related to children custody. Well, for both, the court will adopt conciliatory procedures when appropriate. But FDR and CDR are to be formally become law in the form of subsidiary legislation, because at the moment there are only practice directions from the court. And this has been in place for a long time. Maybe the judiciary can give you figures, but I understand that FDR and CDR have been very successful. Over half of the FDR cases ended up with conciliation. That is, over half of the divorce cases did not have to resolve financial matters or matters related to the custody of children. But of course, sometimes the parties actually went to court. So you can do it yourself, or you can make use of the FDR or CDR under the court. Now, in this exercise, we would like to incorporate them under the rules. Mr. Dennis Ho, Madam Chairman, in the consultation paper, in recommendation 22, the consultation paper asks its readers whether or not before any litigation, conciliation services need to be provided. So this is also proposed under procedural recommendations. Well, yes, I understand that there are a lot of successful conciliation cases. Any room for improvement? And Mr. Ho mentioned a paragraph in the consultation paper. Yes, please, yes.
There's some confusion over terminology here. We're talking about two different things. One is conciliation, which is the paragraph that Mr. Ho has just referred to, and that is conciliation to encourage the parties to abandon the proceedings and, in fact, to reconcile. That's the conciliation that's being discussed at that part of the report. But I think, Madam Chairman, that you're also referring to mediation
Yes.
and alternative dispute resolution, one of which form is mediation outside of the court process, where an independent mediator assists the parties to come to agreement in respect of both financial matters and in respect of child matters. And then that agreement is presented to the court and made an order of the court. But in addition to that are the procedures that Mr. Jeremy Chan has referred to, which is the financial and child dispute resolution hearing before the judge, where the judge effectively acts as a guiding mediator to encourage the parties to reach an agreement in respect of the matters that are in dispute. And the judge, if it's a financial matter, if the parties are unable to resolve their differences in the FDR hearing, that judge will then take no further part in the proceedings. And if it has to then go to trial, it's tried before another judge. But in relation to child matters, the child matters are open in any event as between the parties, and so that a judge if there is a failure to agree at the end of a child dispute resolution hearing, that judge can continue to hear the child matters. So the success that has been referred to is the success in relation to the FDR and CDR. And I mean, certainly from I think all of our experience, the judges are very anxious to ensure that litigants in person are treated fairly in the process. And the process of FDR and CDR, the judge will actually ask the parties, even if they're represented, what their own views are. And there will be something of an exchange of ideas rather than merely advocacy on the part of an advocate or cross-examination of witnesses. So the processes do very much take into account the sort of concerns that, Madam Chairman, you've expressed in relation to unrepresented litigants.
Yeah. 多謝溫生。咁咧就
Thank you, Mr. Wingfield. Procedurally, would you absorb experience from other jurisdictions, for example, by providing a cooling off period in terms of family disputes? In actual fact, under Hong Kong's substantive laws, a cooling period is already provided because after the issuance of a petition, you need a provisional divorce order, then at least you have 6 weeks before you can get a final divorce decree. And in actual circumstances, in reality, very rarely do we see a short period of 6 weeks. From the provisional order to the final divorce decree, a few years may have elapsed. Maybe you can have a period of 5 years during which you're still husband and wife. Of course, you may not have an official period known as a cooling period, but you'll have a long period of time for both parties to deliberate on whether or not they really want to take out a final divorce decree. Thank you, Mr. Chan. Hong Kong's litigations do last for a long period of time. We understand that in successful experience, a third party may be involved in this cooling period to assist both parties. Because if they are to wait for a listing time, only lawyers will be involved in legal procedures. Nobody will be there to assist the family itself. So it's worthwhile for you to take reference from these jurisdictions. There are a lot of successful cases. Now, any more members who would like to speak? If not, we'll have to handle a suggestion from Mr. Dennis Kwok. He would like the administration to immediately follow up on the LRC's report in 2005, particularly in relation to the custody of children, the access to children. I'm now distributing the motion to members. Just now, in the second round of questions, Mr. Dennis Kwok already explained the necessity of this motion. Now, in his motion, he mentions the 2005 report. Today, we don't have any opportunity to discuss that report in detail. Perhaps I should give 2 more minutes to Mr. Dennis Kwok to explain his viewpoints to members. That will be fairer to other members. Thank you, Madam Chairman. Well, this is a report published by the LRC on the 7th of March 2005. That is the report on custody and access. And just now, I also cited the judgment of Justice Lam of the Court of Appeal, and that citation was also on the same report. I'd like the administration to, as soon as possible, follow up on the recommendations made by the LRC in that 2005 report. Very soon, we'll be discussing on the follow-up work on LRC reports and recommendations. Some reports have been published for 5 years or even 10 years already. So if the administration is not to follow up on those reports and recommendations, in future, who else will want to work on such reports? So my motion is simple. It's just to urge the administration to immediately follow up on the recommendations of the 2005 report of the LRC. Well, Mr. Dennis Kwok has made himself very clear. I'd like to ask members whether there's any objection to handling the motion here. If there's no objection, we'll handle the motion. Those members who are in favor of the motion, please raise their hands. Well, basically, all those present are in support of the motion. I see no objection. So the motion is carried by this meeting. We'll now proceed to the next item on the agenda. I'd like the administration to observe that this panel is really very concerned about the substantive laws and procedural laws related to matrimonial and children matters. So don't just handle one aspect of these issues. So please act more expeditiously on the 2005 report. Next item on the agenda, reform of the current system to determine whether an offense is to be tried by judge and jury or by judge alone. The paper is paper 921-01, a letter from Mr. Dennis Kwok dated the 18th of July 2013, requesting us to discuss the issue. This is in English only. And we have another paper 569-04, the administration's paper on reform of the current system to determine whether an offense is to be tried by judge and jury or by judge alone. Now we'll invite the representatives of the Department of Justice to brief us on the paper, and then we'll invite the representative of the Bar Association to speak.
主席，好高興今日有應事務。
Mr. Young, Madam Chair, I'm very glad to report the latest progress on this matter. Now, in our document, there has already been a full account. I will not reread that, but let me highlight several points. Firstly, as we said in the document, the court decisions in the past regarding the Basic Law and Hong Kong Bill of Rights Ordinance, it's already made clear that there is no power given to the defendant to choose the venue of trial. Nevertheless, the prosecution division has not stayed inert. We already explored with the legal professional bodies, etc., on how to reform the system. And in September last year, the DOJ announced a very important document, that is the new prosecution code. Now, regarding the new code, I hope to make 3 points. First, the prosecution division, regarding the old prosecution guidelines, expanded the portion on venue of trial, and the new code can be seen in the appendix. And the new code, we believe, will help our prosecutors in deciding the venue of trial, make more complete and comprehensive consideration on which court is more appropriate in identifying the court that is more capable of coming to a decision. And Article 86 of the Basic Law says that the trial by jury system in Hong Kong will be preserved. In the new prosecution code, in para 8.3, we mentioned this article of the Basic Law so that the prosecutors and the public can understand the legal system in this aspect. Now, thirdly, in drafting the code, the prosecution division already considered the matters of concern to the legal sector, and we will continue to maintain communications with the legal professional sector, and the legal and the DOJ continues to maintain an open mind. We would like to thank the Bar Association and the Law Society for the valuable views that they've offered to us. Now, if there is no further representation from the administration, we will ask Mr. Blanchflower of the Bar Association to speak to us.
Madam Chairman, for bringing this matter back on the agenda. It was last before this committee 4 years ago, June 28th, 2010. I first offer my apologies from the Bar Association for not preparing a paper on behalf of the Bar Association. The Bar Secretariat contacted the Secretariat and asked whether your committee required any paper or the correspondence that had been exchanged between the Bar and the DPP, and we were told no. And that is the reason why we do not have a paper prepared for members. And I say that just not as an oversight, a technicality, because it's such an important matter, particularly where this topic was before the committee 4 years ago. It's not just a matter of choice of trial. It is a matter of the trial by jury, which is a matter of substance, not just a matter of ordinary procedure. And therefore, what I will be asking, Madam Chairman, subject to your approval and members' approval, is that after today, this matter be adjourned to perhaps a date in the fall where the parties can provide a paper which would be of use to members to fully explore a number of things. One is to address the very important topic as to trial by jury, what it means, what has been said, what have courts of final appeal, what have leading jurists talked about it, because we need to understand the topic. Secondly, to review the dialogue in the last 4 years, what has happened, because the papers that your committee has today obviously present a one-sided view as to what has happened. Thirdly, to bring members' attention to recent developments in the law, certainly internationally, on where you have attorney generals deciding what courts a matter shall be tried in, which obviously affect the sentence. So, Madam Chairman, what I'm going to be asking at the end is that the matter be adjourned, say, to the fall, not to have it adjourned sine die, because I would like to have this matter brought before the committee again. With those opening remarks, when we last met, on the agenda was trial by jury in the district court. And that, I think, has proven to be almost an impossibility. It will require legislation, and it would not be in our lifetime that we could have that brought into place. Instead, we have been advocating for the last 4 years to try and persuade the DPP to review and revise his criteria for choosing venue for trial. we have gone through 3 DPPs. That's how long this matter's been under discussion. I may say from the standpoint...
First, I'm sorry, Mr. Blanchflower, because at the development panel, there is now a voting going on, and I have promised them that there will be an adjournment for 10 minutes so that the members here can go over to vote. We will have an adjournment for 10 minutes, and then we will come back and we will continue to listen to your views. I have to go over too.
多謝。
First of all, I'd like to thank Mr. Blanchflower for his understanding. We now resume our meeting. Please continue with your remarks.
Madam Chairman, where we're talking about the jury trial, it is, as many of you know, a very important common law right. And it was a common law right up to just past the Second World War. And as I said, various high courts, courts of final appeal in many jurisdictions and leading jurists have spoken about the importance to individuals of a trial by jury. It's the guardian of liberty, guarantees the sound administration of justice, protects individuals against oppressive laws. That right, at the present situation, is enjoyed only when the DPP decides by choice of venue that it should be tried by a jury, apart from certain offences that have to be tried by jury. The paper prepared by the DPP makes numerous references to a case of Lily Chiang. Now, I wouldn't want members to read too much into that case. That was a case of judicial review. And all it said is that the decision by the DPP to decide a trial in the district court was not unreasonable in the usual judicial review sense. It did not, and one can see the judgments, address the wider issues of the importance of trial by jury. So one can't read too much into that case. In the material that was provided to members in June of 2010, the Bar Association made some reference to the importance of trial by jury. But here we have a situation in its application by the DPP's discretion. We have a recent case of money laundering in the district court of some $400 million. I was recently involved with a conspiracy case of $2 billion tried in the district court. I was recently involved in a case involving 6 professionals, the Shanghai land case, lawyers, financial people, tried in the district court, where their honesty, their credibility was key. Ultimately, thankfully, they were all acquitted in the Court of Final Appeal. But one just shakes their head sometimes, wondering why some cases are in the district court. And I say not only from a defense perspective, but certainly the public has an interest in the proper adjudication of cases. Now, over the last 4 years, there have been discussions between the bar and the DPP, and to put it in a very simple term, it has been disappointing that many of the matters taken up by the DPP, some have been reflected in the code, but there are still numerous inadequacies, and we made that known to the DPP in January after the new revised code came out. So as matters presently stand, the Bar Association, and I don't know what the position for the Law Society, is not satisfied with the present code. I can go in a number of reasons. There's no indication of the importance of jury trials. Now, this code is not only for prosecutors, it's for the public. It should give guidance to the public. And dealing with prosecutors, very often inexperienced prosecutors who themselves have little or no experience with trial by jury, gives no indication of the importance of this trial by jury. The present code repeats many of the points in the earlier guidelines. It does set out factors, and you'll see that present code in enclosure number 2. Now, whether members have it before you. 8.4. A, B, C, H, and J were all found in the earlier code, and so it's just been put under a different paragraph and relabeled. But when you look at A to I, it is a mere statement. There's no guidance, no indication, no examples of how it should be applied. What it leads to is arbitrariness and lack of consistency in decision making. So any prosecutor looking at this wouldn't see how various factors are to be weighed in favor of a jury trial or a district court trial. Matters of particularly dishonesty, which are very important in many cases, are not specifically addressed. And there is no addressing the very important matter of the representations from defendants. Now, in the DPP's paper, it says, as far as representations in paragraph 9.4, representations are not ignored. Code does not intend and should not make one feel inhibited. Well, if representations are important, it should be in the code. When you look at guidelines in the UK, DPP guidelines, they are thick documents which give considered and detailed reference as to how decisions are made, not only for the public but for individuals. Now, what the paper doesn't appreciate and mention is that in January of 2013, the European Court of Human Rights ruled in a case which involved the Attorney General of Malta deciding which court a person should be tried in, and the decision would affect the punishment. Now, albeit it wasn't a matter of whether judge alone trial or jury trial, but the importance of that decision was that it held it was unlawful under the Article 7 of the European Convention on Human Rights, which finds its counterpart in Article 12 of Hong Kong's Bill of Rights. It found that without guidance, without any indication in law, that it gave rise to arbitrariness. And so, for those reasons and more, Madam Chairman, the Bar Association is not satisfied with the present code. We do not believe that it has moved the matter substantially from where we started our discussions 4 years ago, and that's why I would invite this committee, Madam Chairman, to bring this matter back on the agenda, perhaps in the autumn, so that members can be afforded a paper setting out the Bar's position in greater detail to study. Thank you very much.
好，多謝你，Mr. Blanchflower。咁咧就
Thank you very much, Mr. Blanchflower. You have raised a number of invaluable points for our reference. Well, up to this moment, I only saw one hand. Oh, now 2, 3 now. I'll first give each member 4 minutes. I want to be more lenient. First, Mr. Dennis Kwok. Thank you, Madam Chairman. Madam Chairman, I'd like to ask the representative of the Bar Association a question.
Now that the prosecution code, the Bar is obviously not happy with the way it has been revised. I'm talking about paragraphs 8 in the code. Could you give some perhaps recommendations or examples in which you think the code could be further improved and to address the concerns you raised just now?
Yes, in all the matters that we see set out in paragraph 8, first of all, we would urge the DPP to set out in his code in a summary form or in some details, and there should be no inhibition as to the size, to reinforce and put it clear what trial by jury is and its importance in the common law system, so that their young prosecutors and the public can see the importance of a trial by jury. So we know what we're talking about.
So to set out basic principles of the fundamental importance of trial by jury as a right.
Yes, and just to repeat what final courts of appeal, what leading jurists have talked about the trial by jury, so that prosecutors have that firmly in their mind.
I understand. 楊專員會唔會有啲咩回應？
楊專員
Mr. Young from the DPP, any response?
話關於我哋香港嘅判例，我哋唔應該。
Mr. Blanchflower said that we shouldn't read too much of the Hong Kong judgments because they are only precedents regarding the judicial review. But I would like to read several paragraphs of it. It doesn't go to whether that decision was reasonable. It also goes to whether in the context of Hong Kong, whether there is a choice for jury to be employed in a trial, the right. Now, in the paragraph of that judgment, the judge said,
on any absolute right to trial by jury, nor any mechanism by which a person to be tried of an indictable offence may elect to be so tried. The decision as to whether an indictable offence be tried in Hong Kong in the court of first instance by a judge and jury or in the district court by a judge alone is the prerogative of the Secretary for Justice. 呢個係原審，去到上訴庭嘅時候。
Now, that was the original court. Now, now Mr. Ma, the current CJ, said in paragraph
that these appeals are not about whether a right to a jury trial exists in Hong Kong. It is accepted that there is no right or entitlement as such. It also ought to be made clear that while the applicant wishes to have a trial by jury, it is accepted that there is no question of any unfairness where a trial is to take place in the district court. 同樣嘅説話呢，喺
the same wording in Justice Ma's judgment, paragraph 24, is also repeated. And then when it goes to the CFA, Mr. Lee, the then CFA CJ said in paragraph 9.
有個問題就係，當然喺1953。
Of course, in 1953, because before Hong Kong had the district court, now the Hong Kong's common law recognized there was a right of jury trial. That's a different matter. But since 1953, the system has has become completely different. Now, based on the HKBORO and the highest court, according to the highest court, Hong Kong is no longer like other common law jurisdictions. It has a completely different view now. Now, I heard Mr. Blanchflower say that in the prosecution code, there should be mention of the spirit of the common law. But this is no longer applicable. I have reservations that some common law principles that no longer apply. Why should they be repeated in the prosecution code? The second member can speak, Mr. Paul Che. Now, I think democracy, the democratic system, is about universal suffrage. There's no ultimate universal suffrage or true or false, but it's like a northern star. Now, jury trial is like the northern star. It's every country should move in that direction. I think Mr. Young will not deny this. In 1952, we set up the district court. In the document, it said now, and also in 1997 there was a document regarding right of trial regarding the district court. It's also mentioned that one of the main reasons why in the formation of the district court in 1952, why didn't they adopt the jury system, is because they were worried that there weren't enough jurors. Now, we have an English language requirement that's not present in the UK. Now, at the time, there were not that many people who are qualified in the English language, but after 1997, the language of trial is different, and the education attainment is now different. So that concern has lessened or even disappeared. So I think that background can be more understood. Also in the basic law, it's been mentioned. Now the basic law didn't say that one have a trial to jury right, but existing articles 86 and so on, is there any barrier to having jury trial in district court? Articles 81 and 86 don't pose such a barrier. It merely says that we should preserve the jury trial system. It doesn't say that there should be no improvement to move in the direction of the Northern Star towards a jury trial system. Now, if the administration doesn't have an answer now, I agree with Mr. Blanchflower that maybe next time we can have more information and we can reconsider the issue. Now, there are two factual bases that I hope the administration can respond to. First, in the past, the district court, relative to a court of first instance with jury trial on the conviction rate, district court was the percentage and high court with jury was the percentage. Can we look at the figures for the past 5 or 10 years? Secondly, now if we extend the jury trial system to district court in terms of practicability, in terms of costs or administration of court costs, how much of a burden would that be? I hope next time the administration can supply those figures. Mr. Young, can you respond whether the basic law poses an impediment? Now, regarding whether there's an impediment in the basic law, we look at it from two perspectives. Firstly, when we talk about so-called right, we are talking about two different things. First, the right to choose trial by jury, that's a right of choice. Secondly, accepting trial by jury, that's a right. And regarding the right of choice, now, in 1977, there was already an appeal court decision that throughout common law, there is no right to choose the venue of trial. And regarding jury system, the right to answer to defend oneself in such a court, there has been major changes in our system, in our background. Now, the Basic Law Article 86 says that the existing trial by jury system or principle will be preserved. Now, if we take into account this background, now in the when the Basic Law was implemented, now at the time there was no system of or right of trial by jury. Secondly, even regarding the right to be heard before a jury, now the 1952 District Court Ordinance already changed that to a major extent. Now, if we put Article 86 of the Basic Law back into that temporal context, now, from the perspective of study of law, then it can be only said that the jury system at that time will be preserved unchanged. Now, if that jury system is A, and if that's to be changed to B, there will be a constitutional problem. Now, that's the way we can look at it. As for Mr. Paul Chair mentioning another issue, that is, if the jury system is to be implemented in the district court, and what's the financial burden. Now, that has been discussed in the past, and if you want the information now, I don't have the information now, and I think Mr. Paul Chair understood that when he asked the question. As for the conviction rate, I do have some figures. Now, I have worked out some sums. Now, if you hear these, they might be instructive. Now, of course, if we all move towards the northern style of justice, and as a barrister myself, this is my lifelong pursuit. Now, as for the form of that fair trial, now, if you look at conviction rate as a benchmark, then I can say in the district court since 2009 to 2013, in that 5-year period, the conviction rate, excluding the conviction after plea, I'm talking conviction after pleading not guilty, now 69.2, 79.8, and so on. The average rate is 72.6. That's for district court. Now, as for CFA with jury, the defendant pleads not guilty and then is convinced. And if you look at the same record for the same 5 years, 09, 65.3, 71.7, 72, 69.6 and 67.3, and the average is 69.18. So I repeat, the district court average rate is 70.62. The CFA, the court of first instance is 69.18. Now, if you take into account the conviction after including pleas of guilty, now in the same 5-year period, it's 91.3% for district court, and for CFI is 92.8. The difference is less than 1 percentage point. Now, if we look at the percentages, they are instructive to a certain extent, but of course the criminal cases are of different nature in those courts, but at least we get these figures. Next, Ms. Ann Chang. Now, looking at the document, it mentions Lily Chang. I must say that Ms. Lily Chang is related to me, but I have no interest involved, and moreover that case has been concluded, but I will not make specific mention to that trial. I'd like to ask, rather, we know that right now in other jurisdictions, in many advanced jurisdictions, they have a jury system. Actually, I would like to hear the DPP's view. Why is it that those countries have a jury system? Perhaps the DPP can take his time to respond. Mr. Young, of course. I can't say that countries without jury systems are not advanced, but it's a fact that most advanced countries do have jury systems, and that is a fact. Now, the jury system, for instance, Australia, different provinces have different modes of application of the jury system. Now, under the jury system, firstly, what trials must have trial before jury. Who is to decide whether the offense should be tried before a jury? And the right to choose, does it lie with the prosecution, the defense side, or the court? Now, especially when the two parties cannot reach agreement, how is the court to decide? When the court decides, does it hear the defendant's right of choice? That is, does the defendant's right of choice is it overriding?
Different jurisdictions have different modus operandi and different jury systems. So here I won't tell you a jury system is not practicable, and theoretically it is impracticable to allow the litigants to have a choice. I won't say so. In 1953, we started to have the district court system. For so many years, our court system and prosecution system have undergone changes. If there are to be changes, to what extent should these changes be fundamental in nature? I can say that any such changes will be fundamental. In overseas jurisdictions, their jury systems had continuously operated without any suspension or termination. Dr. Chang Lai Wan, well, I've only got 4 minutes, and you have already spent 3 of my 4 minutes. Well, let me sum up. Yes, it's feasible, but then in Hong Kong, if we are to adopt that sort of practice, then many magistracy cases may go to even the Court of Appeal. Dr. Chang Lai Wan, Madam Chairman, I'd like to tell the DPP that many jurisdictions have already adopted a jury system. And of course, they do have their merits. Well, where are their merits? I believe the DPP understands the merits of a jury system, so I won't dwell on the details here. For example, in Hong Kong, many of our laws modeled on the UK system, and I understand that in the UK they do have a jury system. I understand that sometimes, even if the case involves the stealing of one candy, the defendant may ask for a trial by jury. As regards the code, let me cite the example of 8.4. The prosecutors can choose between the magistracy, the district court, or even a higher echelon of the court system. Well, the code should be clear. If it is a minor offense, of course, it is unreasonable to have it tried in front of the district court. The magistrate's court will suffice. But if a party voluntarily requests that the case be tried in front of the district court, should the administration or the judiciary not consider that request? As for 8.3, in relation to Article 86 of the Basic Law, as far as I understand, the original jury system and judicial system should be maintained. That's my understanding. What is already in place should be maintained. But if you want to add anything, well, let me say this. Day after day, you're making new laws, and these are new things. Justice Hartman said something about Article 86 of the Basic Law.
As previously practiced in Hong Kong. But of course, as it was previously practiced in Hong Kong was according to specific factual circumstances then, and those circumstances have changed. As previously practiced, of course, goes to something more fundamental than the exigencies of any particular situation in history. For example, how many jurors there were in 1977 as opposed to how many jurors there are now. 咁咧就喺1977年咧，當時司法界
In 1977, the judiciary also mentioned something about the jury system. At that moment, there were only 20,000 qualified jurors. Now we're in 2014. That number has far exceeded that number. It's estimated that we now have 60,000 qualified jurors. So that satisfies one of the provisions in the Basic Law. I also want to ask some follow-up questions. Just now I have accorded 8 minutes to some members. There are not that many members who've raised their hands. So I'd like to ask some follow-up questions first, and then I'll invite Mr. Young to respond to the bar as well as our own members. First of all, I agree with Mr. Blanchflower. We are very willing to put this issue on our list of outstanding items. Mr. Young commented a great deal on the jury system. May I refer you to Article 86 of the Basic Law? As far as I understand, that provision says that our jury system should not be changed because of the handover. But that does not mean that the jury system should remain status quo forever. So my understanding is if there are proposals to reform or improve the jury system, that's not against Article 86 of the Basic Law. Just now, Mr. Blanchflower also mentioned that they saw and observed that there are arbitrariness, inconsistencies, and practical problems in the existing jury system. A few years ago, there's this doctoral dissertation from the City University that discuss the pros and cons of the jury systems in various jurisdictions. And they even mentioned the cyber jury system. You see, from TV dramas, you always see jurors being confined to a small room for a prolonged period of time. So that thesis touched upon various jurisdictions and their jury systems. And many jurisdictions have come to Hong Kong to observe what's happening in Hong Kong under our jury system. So at our future meetings, we can invite other stakeholders to this jury system under a common law jurisdiction to discuss with us. Knowledge-wise, language-wise, and so forth, we have various requirements, and there are restrictions to who can serve as qualified jurors. I believe the DPP has been overly conservative in his position. I think we can look at the experience elsewhere in the world. Well, yes, there may be shortcomings with the jury system, but the jury system has played a very good historic role in our judicial history. So I believe in future we can invite more stakeholders to come and explore this issue with us. Oh, Mr. Abraham Sheikh, you would like to speak? Well, I'd like to seek evidence on a certain point. I heard the DPP very clearly. Was he using number 8 to interpret Article 86 of the Basic Law? Well, let me explain. I've drawn a line already. But just now, we have suspended this meeting for 10 minutes, and I do have the right to extend the minute by 15 minutes. If Mr. Abraham Sheikh is very interested, I can give him 4 minutes. I don't need 4 minutes. I'd like to know whether or not he's using number 8 to interpret Article 86 of the Basic Law. Mr. Young, concerning Article 86 of the Basic Law, in answering Mr. Jay's questions, I mentioned one possible interpretation of Article 86 of the Basic Law, BL 86. In Lily Chang's case, the judge of the first instance put forward some of his views. He reiterated BL 86, and then in paragraph 16 of the judgment, he said something.
Is that whatever principle applied in relation to jury trials prior to the Basic Law coming into effect would continue to apply thereafter. The applicants cannot be in any better position now than they would have been prior to the Basic Law coming into effect. They will be in the same position. What was the principle which was previously practiced? 跟住佢問完呢個問題之後呢，就引用咗一啲。
And after saying that, he cited some precedents. And then finally, in paragraph 19, he also said something.
Prior to the Basic Law coming into effect was clear. An indictable offence was triable either by judge and jury in the High Court or by trial or by judge alone in the District Court at the discretion of the Attorney General. The order of the magistrate transferring the trial to the District Court is one which is not subject to appeal. The Attorney General's discretion was, and hence the respondent's discretion is unfettered, although not necessarily entirely free of judicial supervision. 其實就係基於呢一幾段呢，我提出呢個係一種睇法。
So I meant that under Article 86 of the Basic Law, the original jury system and the original principles underlying the jury system should be maintained. I'd like to adopt a more open attitude in interpreting Article 86 of the Basic Law. In answering members' questions, I put forward those comments. Next time when we come back, we'll try to compare more jurisdictions on this issue. Mr. Blanchflower mentioned 8.4 of the code. At the beginning of this year, Mr. Blanchflower sat down with me to discuss the issue. We also had some written correspondence. I understand the viewpoints of the Bar Association. Number one, whether or not we need to repeat in the prosecution code what's under the common law jurisdiction, that is the pros and cons of a jury system. I've already tried to explain the DOJ's position. Whether or not the litigants can make statements on this issue, in our exchanges with the Bar Association, I said that in different cases, in different jurisdictions, modern lawyers will present their viewpoints to the prosecution in their statements, and the prosecution will absolutely consider those views. We've not included that in the code, but that does not mean that those viewpoints are not important. The code sets out 9 points which are repeating what's in the previous guidelines. I think that remark is not very fair. 5 of the 9 points can be found in the former guidelines, but 4 are completely new. And among these 4, 2 are particularly important. In the course of drafting the prosecution code, we heard views from the Law Society and the Bar Association, and these 2 points were added in, particularly. F, whether or not the defendant has enjoyed a high social status and with very important posts and responsibilities. And then just now Mr. Blanchflower said that the code does not mention particularly that honesty cases should be brought in front of the district court or high court. But I think here we're concerned about facts and social standards and values. Whether or not it involves honesty is also covered by social values. Mr. Blanchflower also mentioned the professionals. He said, or rather he asked, whether because of these people's status they should be tried in front of the High Court. We also considered that aspect in detail. Well, if you say the professionals are entitled to do something, then does it mean that non-professionals are not entitled to do something? Madam Chairman, there are a number of issues to be ironed out here. In future, if the panel wants to rediscuss certain issues, I would be very willing to assist.
Our time is really up today. I think we will put this in the list of matters for discussion, and Mr. Young has said that the existing system will not be changed. Now, there are similar clauses in the basic law but that doesn't mean that we don't have room for improvement. I thank the Bar Association's representative, Mr. Blanchflower, and the representatives from the DOJ. Our time is concluded, and thank you for attendance. Now, the Bar Association representative said that they will prepare a more detailed representation. Now, if possible, can you please let us have this representation a bit well ahead of our next meeting? Yes, this is what we will do it, and we will also invite other people who might have conducted valuable studies. Thank you.